Okay. Good evening, students. Good evening, everyone. I hope you all are doing fine. So, first of all, I welcome each one of you to my class on Code of Criminal Procedure 1973. Let's start with my brief introduction. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen. Students, here is the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask your questions in relation to your judicial preparation. This is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. So the moment you feel you're not clear with anything, feel free to ask your questions in the comments and I'll answer accordingly. Very good evening, Trisha and everyone, those of you who have just joined. So I hope you all are ready for the important MCQs. So here comes the very first MCQ on your screen. Before starting the test, just a humble request, students. Before writing your answer, make sure you write down the question number in the numeric form. So first write down like numeric 1 and then whatever your answer is, A, B, C or D. Okay. So here comes the first question. What were the basic consideration in the minds of the makers while drafting CrPC? So while CrPC was being drafted, what were the basic principles were in the minds of makers? Option number A, fair trial. Option number B, it must avoid delay. Option number C, procedure not to be complicated. Option number D, all of the above. Trisha, first one to answer. That's the correct answer, Trisha. D is the correct answer. Now let me tell you, when it comes to 41st Law Commission that basically drafted CrPC, all these 3 points were in the minds of the makers. Like fair trial here means fair trial for the accused and for the victim, for both of them. Okay, to avoid delay, as justice delayed, justice denied, and the procedure must not be complicated. It should be a simple procedure. Okay. Next, which of the following chapters will be applicable to states of Nagaland and tribal areas? So this question is from section number 1. Option number A, chapter number 8, 10 and 11. Option number B, 6, 11 and 9. Option number C, chapter number 5 and 7. Option number D, chapter number 6, 7 and 12. Okay. Students, this question is from section number 1. So what section number 1 says? The short title and the extent and the commencement. So when it comes to the concept of extent, it extends to whole of India. Previously, before 2019, it extends to whole of India except the state of Jammu and Kashmir. But after the Jammu and Kashmir Reorganization Act 2019, it is applicable to Jammu and Kashmir as well. But this will not, CRPC will not be applicable on the states of Nagaland and tribal areas. Now, what is the reason? The reason is that the states, the tribal areas are still not ready to accept, the overall culture of the modern India. So they are doing their own things. So, but still, the complete CRPC will not be applicable to them, but still, there are three chapters which are still going to be applicable on them, and those are chapter number 8, chapter number 10, and chapter number 11. Now, coming to the question, why only these three chapters are going to be applicable? So, when it comes to CRPC, there are total 37 chapters. Now, coming to the application of only these three chapters, because these three chapters are basically of to prevent any kind of offenses, to maintain peace and order in a particular state, which is again mandatory. So that is why only these three chapters are applicable. In addition to that, there is a power that has been given to the state government that if they want, they can apply some part or some part or any additional part of the CRPC to that state. So state government holds that power. So the correct answer here is A. I hope it's clear now. Next one. Non-bailable offense defined under section. So section 2 is basically your definition clause. Various terms has been defined. All the all the terms are very, very important. So when it comes to non-bailable offense, this term has been defined under section 2B, 2F, 2G, 2A. Students, the correct answer of this question is 2A. Okay. So when it comes to bailable offense and non-bailable offense, both the terms are being defined under section 2A only. And section 2A will take you to the schedule 1 of CRPC. Okay. So basically, in the schedule 1 of CRPC, there are 6 columns, and out of those, one column is about whether the offense is bailable one or non-bailable one. Okay, so whether it is bailable offense or non-bailable offense, both the terms defined under section 2A only. Okay, one more thing, students, when it comes to this definition clause, this is something which is in alphabetically order. So starting from 2A, it starts with bailable offense, and 2A only non-bailable as well. Okay, and then go on with charge, cognizable offense, complaint, so on, high court, and so on. What is the purpose of investigation? One of the most important concept. There's a saying that you can divide the complete CRPC into 3 topics. That is investigation, inquiry, and trial. And that's it. You are done with the complete CRPC, right? So what is the purpose of investigation? Yes, Trisha, your answer is very much visible. I can see your answers. But usually they came late. I don't know, it is the internet or something else. They are visible. Yes, Trisha, waiting for your answer. For question number 4. What is the purpose of investigation? Pushpa Chaudhary, correct answer D. So students, when it comes to investigation, it is usually done by the police officer. But when you will go with the definition, it is also a collection of evidence by any person who is authorized by a magistrate, but not the magistrate. Okay, but not the magistrate. So these two statements, collection of evidence by police officer, collection of evidence by any person authorized by the magistrate, both will fall under the purpose of investigation. So both A and B are the correct ones. Okay. Yes, Trisha, I got your answer. D. Okay. Next one. Which of the following is not a criminal code under section 6? VR classes. I got your answer. D is the correct answer, students. When it comes to, see, first the question is which of the following is not a criminal code? So, court of session, judicial magistrate first class, judicial magistrate second class, or you can say metropolitan magistrate. Okay, done. Or your executive magistrate. They all are basically your criminal code. So, the answer is going to be D, that is none of the above. Okay. Next one. Procedure in case of accused being lunatic. See, when it comes to CrPC, students, so it basically tells you the procedure that once the offense has taken place, now who is going to do the investigation, who is going to do the inquiry, how the trial is going to take the place. So the whole procedure is given under CrPC. But when the accused is lunatic, so there is going to be a special procedure which needs to be followed. Reason? Because of the nature of the person. Okay, and this procedure is given under which section? VR classes, first one to answer A, Trisha A. And yes, section number 328. It's a direct question. So section 328 basically tells you the procedure in case of accused being lunatic. Victim compensation scheme. So this is mentioned under section 357A, 357B, 357C, or D, none of the above. So students, when it comes to section number 53 of IPC, that basically tells you the various punishments available in IPC. There is also one concept that you need to read with that section 53, that is the theories of punishment. And when it comes to theories of punishment, there are various theories like deterrent theory, preventive theory. Okay, so one of the theories is there, compensatory theory. So this victim compensation scheme is one of the best example to understand that compensatory theory. Okay. Yes, VR classes, we are talking about scheme here. Pushpa and Trisha, correct answer, that is A, 357A. Okay, is the correct answer. When the court of session passes a sentence of death, the proceedings shall be submitted to the dash under section 366. Supreme Court, High Court, Governor, State Government. Trisha, first one to answer correctly, that is B. High Court is the correct answer, students. See, you need to remember that when it comes to section number 28, it tells you what kind of sentence a court of session may pass. So, accept that sentence, because in case of death, they need to submit it, okay? And submit it to the High Court under section 366. And there comes the role of section 368 as well. So, under section 366, that report, that sentence that should be submitted, and under section 368, when it comes to section 368, there comes the role of the power of the High Court to confirm such sentence. So High Court is the correct answer. Next one. No appeal in petty cases. So when it comes to the concept of appeal, it is a statutory right. It is not a legal right. So you have to go with chapter number 29, whether a person can go into the appeal or not. So as per to chapter number 9, which section confirms this, that if it is a petty case, then there is no concept of appeal because of obvious reasons. First of all, it's a petty case, and then there is no need to go into appeal as well for that. VR classes and Trisha, correct answer. That is section 376. How many minimum number of judges of the High Court are required to sign the confirmation of death sentence? Minimum number of judges of High Court are required to sign the confirmation of a death sentence. Option number A3, B4, C2, D5. Santani, we are on question number 10. We are on question number 10. I hope you have answered for this only. Trisha and Santani, correct answer. That is, minimum number is 2. Okay. Who is not entitled to maintenance? Wife able to maintain herself, father able to maintain herself. Okay, sorry, father able to maintain himself, not herself. Mother able to maintain herself, all of the above. VR classes, first one to answer correctly. See, the question was not entitled. See, as far as section 125 is concerned, wife, father, and mother all are entitled for the maintenance under section 125. But if they are able to maintain themselves, then there is no question of maintenance. And that is why all of the above. Okay. Next. Which of the following is a valid reason for wife's refusal to live with him? Basically, live with husband. VR classes, Santani, correct answer. These all are the valid reason so that wife can refuse to live with the husband and she will still be entitled for the maintenance. Who will maintain the minor unmarried daughter if husband is not capable of? Father-in-law, father, husband only, wife herself. Santani, correct answer. VR classes, correct answer. See, students, the answer is going to be the father only. So, you know, the things which you cannot do directly, you cannot do even indirectly as well. That maxim will be applicable here. So, when it comes to the concept of unmarried minor daughter, okay, ji? So that is the liability of father. Okay. No woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman officer shall, by making a written report, obtain the prior permission of. Sayantani, we are classes. Trisha, okay. Everyone's answer is correct. That is judicial magistrate, first class. A person arrested not to detain more than 24 hours under section. Choose the most appropriate option. Okay, it's B is the correct answer, students. Santani, Trisha, correct answer. So, first important point here is exclusive. The time must be exclusive for when it comes to the for the time necessary for the journey from the place of arrest to the magistrate's court. So B is the correct answer. A non-cognizable investigation starts. Santani, VR classes, and Trisha. Correct answer. That is after obtaining order from the magistrate. So B is basically is the correct answer. A copy of FIR shall be given dash to the informant. VR classes, Trisha, Sayantani. Correct answer. That is going to be free of cost. Students, always do remember that when it comes to uh, uh, FIR, the first information report, it is a public document. Okay, it's not a private document, and it is also not a privileged document. Okay, so it is not a privileged document, it is not a private document, it's a public document. Investigation as to non-cognizable offense under section. Under which section the investigation of non-cognizable offense took place? Sayantani, Trisha, correct answer. Students, when it comes to investigation of cognizable offense, we do have a specific section for that. That is section number 156. But when it comes to investigation as to non-cognizable offense, that is mentioned under section 155 only. So B is the correct answer. Students, when it comes to the concept of occurrence report, there are usually two sections for this. One is what is occurrence report, that all is given under section 157. And how occurrence report submitted, for that we have a specific section, section 158. So the correct answer here is going to be D, 158. Okay. So VR classes and Santani, please do correct your answer. Okay. Under section 154 clause 3, may send in writing by post to the dash for lodging the FIR. Officer in charge of police station, High Court, Superintendent of Police and Magistrate. VR classes, correct answer. So this is your Superintendent of Police. Santani and VR classes, correct answer. Trisha, please do correct yourself. See, under section 154 clause 3, we usually go when the police officer is not lodging the FIR. So you may approach to the Superintendent of Police. Okay. Section 154 clause 1 talks about officer in charge of police station. So who basically lodge your FIR? That is officer in charge of police station or any other officer under his direction. Okay. So here the correct answer is Superintendent of Police, SP. Lalita Kumari versus Government of UP is related to, it's a landmark judgment. It's a landmark judgment. Santani and VR classes, please do correct your answer. It is on FIR. ठीक है जी. Whether lodging of FIR, if someone is giving you information about the cognizable offense, it is mandatory or not. So option number A is the correct answer. Which of the following may record confession under section 164? Santani, Ashutosh, and Trisha. Everyone's answer is correct. That is judicial magistrate. Maximum period of police custody by magistrate. This is as per to section number 167, when the police officer is not completing the investigation within 24 hours. If the investigation has not been completed within 24 hours, then the procedure is laid down in section 167. So whether the accused will go into the police custody or the judicial custody, and if the magistrate may send him to the police custody, so what is the maximum period for that? Santani, Ashutosh, and Trisha. Correct answer, 15 days. And when it comes to your judicial custody, sorry, this is about executive magistrate. Next question is going to be about the judicial custody. So the same power. So at that point of time, that power for 15 days is given to the judicial magistrate. And now we are talking about the executive magistrate. Aru, the correct answer is 15 days. Okay, Aru? You may refer section 167 as well of CrPC to confirm the answer. Okay? Yes, it's Santani and Trisha. Correct answer. Okay, Ashutosh also correct answer. Okay, I have one question to you. Let's assume, okay, let me give you a very good question here. So suppose the police officer took the accused to the executive magistrate and he got 3 days of police custody. Okay, and after that, now the judicial magistrate is available. Now the police officer for the very first time went to the judicial magistrate. Now those 3 days which were given by the executive magistrate, they will be that time will be deducted from 15 days, or that is something which is in exclusion of 15 days. Please answer. I hope the question is clear. I'm repeating myself. My question is that when it comes to the judicial magistrate, the maximum time period is 15 days. But if a police officer has already taken the police custody of suppose 3 days from these 7 days, so that is going to be deducted from 15 days or not, or that will be in the exclusion of those 15 days. Deduct, Trisha. Ashutosh, correct answer. Ashutosh and Trisha, correct answer. Okay, so if someone has taken 3 days from the executive magistrate, now only 12 days are left for the judicial magistrate. Okay. Default bail. The accused has indefeasible right to bail when investigation is not completed within. Good evening, Rajneesh. VR classes Santani, Ashutosh, Trisha. Everyone's answer is correct. That is 90 or 60 days. You must know when in the case when it is 90 days or when it is going to be considered as 60 days only. Now, anything which you are not clear with, you may ask. Yes, please. This is the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. Students, this is the link of my Telegram channel. Recently, today only, I have completed all the 9 acts, 9 special laws, which has been recently added in the UP Judiciary exam. Okay, so in case if you are preparing for UP Judiciary also, you can use my code Khatri10 and you can get access of all those free classes. Okay, and you can go into my profile and go for search for the classes. And in case if you are not able to find the link, you can ask me for the link on my Telegram channel as well. Okay, so this was about me. Let's crack PCSJ with Unacademy. There is going to be a rapid revision batch which is going to be start from 23rd Jan for West Bengal Judiciary. And Unacademy is introducing Judiciary PCSJ Scholarship Test 2023, which is going to take place on 15th of January at 12 p.m. And you can win scholarship worth up to 100%. VR classes, I think on Unacademy, there are already, educators who are taking classes for Punjab Judiciary. Okay, but still, if you have any specific doubt, you may ask me on my Telegram channel. Okay, so there are already classes going on where, mock tests are taking place for Punjab Judiciary examination. You are welcome, Santani. Okay, Trisha. You're welcome. Anything else, students? Okay, so that's it from my end. See you in my next class. Till then, yes, it's time to say